Alrighty, folks, looks like we are live. I'm George, one of the founders of Solo Suit, here with friend John Skiba. John, can you go ahead and tell us a little bit about yourself, your practice?
Yeah, George, it's good to be here with you again. I'm John Skiba. I am an attorney in the state of Arizona. I handle consumer debt type cases, junk debt buyer lawsuits. I also do consumer bankruptcy practice, Chapter 7s and 13s. How we connect is I have a YouTube channel, the Consumer Warrior YouTube channel, where I talk a lot about these same things that we're going to talk about today, as far as how to deal with some of these debt collection lawsuits. And all that kind of stuff. My law firm website is consumerwarrior.com. If anybody wants to learn more about me, but I'm glad to be here today.
Fantastic. Thanks for a little intro. We're going to be talking about how to settle a debt with Midland Credit Management today. So, can you tell us who is Midland Credit Management?
Midland Credit Management, Midland Funding, their sister companies, they're one of the kind of original junk debt buyers. So their parent company is a company called Encore Capital, and what they do is they go and they buy old charged off credit cards, medical bills, that kind of thing. They buy those from the original creditor at pennies on the dollar. The FTC did a study on Midland Funding, said they pay on average 4 cents on the dollar for their debt. So they go out, they buy the debt in these big portfolios, and then they file lawsuits in huge volume. The last statistics I saw, they were filing about 500,000 lawsuits a year nationwide. So they're a huge player in the debt buying industry, file a lot of lawsuits. If you're dealing with debt problems or credit cards, you're probably going to see either Midland Funding or Midland Credit Management file their lawsuit. I've dealt with them a lot. They're actually the main company why I really got into defending consumers in these types of cases, just because of the huge volume. They're pushing people into bankruptcy that didn't really need to file bankruptcy. So that's how 15, 20 years ago, I really got started in defending their lawsuits. But that's kind of who they are in a nutshell as far as what they do.
Fantastic. Thanks for the rundown. So you've been doing this for 15 to 20 years now?
Yeah, I just passed 21 years of law practice, and I started my own practice about 2 years after I got out of law school. So I've been doing bankruptcy, and I started out doing bankruptcy. And like I said, I started getting, truthfully, a lot of these Midland Funding lawsuits from clients who didn't need to file bankruptcy. So we started saying, hey, let's defend some of these. And the more we peeled back the onion on their case, the more we saw that there's a mess. There's some huge problems with the types of lawsuits they were bringing. And that's really how we got into defending these lawsuits.
Fantastic. So you're an expert in the space now after 15 to 20 years. That's great. Fantastic.
I try.
For sure. Great. Who does Midland Credit Management usually collect for in your experience? Like, who are some of the, I guess, are they just collecting for themselves usually?
Yeah, well, I mean, I get that question a lot in my law practice, as far as some people think it's the lawyers, the law firm that owns the debt, or they think that, they're acting as a collection agency. Midland is actually asserting ownership. They're saying, hey, we own this debt now. We bought it from whoever they purchased it from, and they're trying to collect on behalf of themselves. However, I mean, the credit card companies, Citibank, Synchrony, I've seen some Chase, I've seen a little bit of Bank of America. They buy from a lot of the big credit card companies. And like I said, the government, the Consumer Financial Protection Bureau and the FTC did a big study of them. And that's what, on average, they pay 4 cents for every dollar worth of debt that they buy. So they buy it at a huge discount, try to get a judgment, try to garnish and collect on it. And that's how they make their profits from it.
Right. So Midland Credit is a debt buyer. So if you're being sued by them, they probably bought your debt from somebody else. And they will usually either bring the lawsuit themselves with their lawyers in-house, or they will hire a law firm to bring the lawsuit. Yep. In your experience, have you seen any trends between, or patterns as to why they might bring the lawsuit themselves with their own lawyers versus hiring out to a law firm?
I've looked at that, and it's usually Midland Credit Management lawsuits are brought by their in-house attorneys. and the Midland Funding ones seem to be out. And I don't know. I've even talked to their attorneys, and they don't share everything with me, but I don't see a specific way, and maybe you have, but I haven't seen a big reason why they don't do it. It is important, I think, to recognize when they're using their in-house attorneys and when they're hiring outside law firms. The reason is because this can help you when you're negotiating a settlement, or if you're actually going to like a trial type setting. In states like Arizona, where I practice, the prevailing party in a lawsuit can often get attorney's fees and court costs reimbursed. So you'll see often that these law firms, Gersta Law Firm is a big national firm, collection firm. They handle a lot of Midland Funding things here. They'll go to trial, and if they win, they're going to not only get the underlying debt, but try to pin a bunch of attorney's fees and court costs on you. If Midland is handling it in-house with their in-house attorneys, at least in Arizona, the courts have not allowed them to collect attorney's fees on top of what it is that they're trying to collect, because they're not hiring an outside attorney to do this. Their in-house attorneys are getting a salary whether your case came along or not. And so that can be just one of the tools. I always say when you're trying to resolve these things, you're kind of poking and prodding, looking for little things that you can give you some leverage. That could be one of them, that they're not going to be able to get attorney's fees and court costs in most jurisdictions if they're not hiring outside counsel. So I think that's one of the important things to look at if you're dealing with a Midland Credit Management or a Midland Funding case.
Okay, great. And have you seen any patterns as to who they will buy debts from?
The most of what I see with Midland, like I said, I see a lot of Citibank type cases, Synchrony cards, U.S. Bank. I see a lot of those. I do see Bank of America often keeps their own debt, but I have seen periodically Bank of America accounts. I don't see Midland doing a lot of, the debt buying market. Sometimes these things trade hands multiple times. In the old days, I used to see a lot of maybe second or third, transactions between the parties. But lately, I've just seen Midland buying directly from, whether it's Synchrony or whether it's U.S. Bank, Chase, someone like that directly. But those are the bulk of what I see, at least.
Okay. Fantastic. And when someone's being sued by Midland, how do they settle a debt with them?
If you're trying to reach a settlement with any of these things, the first things I tell people, if you get sued, I think it's almost always advisable to file an answer. Even sometimes, particularly if you're just trying to settle rather than litigate the case, you want to reach out and try to engage them. And I get that. However, it always makes me nervous. I think as nervous lawyers, we get nervous anytime there's a deadline, because there's a deadline approaching that you can look at your summons, you can see how much time you have to file your written response. Getting an answer filed typically buys you sometimes weeks, sometimes months. Depending on your jurisdiction, it can buy you a lot of time to get more information about the claim, see exactly what it is that they're alleging, see what their proof of ownership is, and really put you in a better position to try to settle the case. So getting an answer filed, we talked about solo suit, you have some great tools there to be able to help people to get that done. I think getting the answer filed is the first step. And then most jurisdictions require some type of disclosure where they have to provide you with any evidence they have, documents, lists of witnesses. I often think it's a good idea to at least see exactly what it is that they're alleging. You'll often see that the documents that transfer the account to them, that they're missing a lot of those. They may not have a lot of what they call media, which is their monthly statements and things like that. And those things can put you in a better position to try to settle. Sometimes you can push the case out of court into private arbitration. You can do the motion to compel arbitration, which I know Solo Suit has some products that can help with that. And that can help give you some leverage as well before you even put that initial offer out there. As far as trends, as far as what I see Midland settling, often when I'm dealing with their in-house attorneys, I see settlements in the 20 to 25% range on most accounts. Some of the other outside attorneys, it's closer to 30 to 45%. Just kind of depends on your personal background, personal hardship, how strong their evidence is or the weakness of their evidence. Those are the kinds of things I look at.
So you see a case settle for 20% of the total debt balance even after a lawsuit's begun?
Yes. And And recognize I'm coming at it too as a practicing attorney on this. I can tell you, I often get better deals once a lawsuit has been filed. I have found when clients come to me and I'm trying to negotiate directly with them, sometimes the people that I'm calling on the phone at, I call it Midland Credit, and the debt collector / paralegal person, they may not have a lot of latitude as far as what they can do as far as settlement. Sometimes the attorneys have, well, not sometimes, all the time, they have a lot more wiggle room as far as what they can do. So that's not to say that you can't reach out and get something done. I've just seen it, particularly when I can go through and articulate why they should take such a lower amount, and that the attorneys give me a better deal. So for a long time there with Midland, we were getting settlements around 20-25%, even after a lawsuit's been filed. But it took a little bit of jockeying to get the case in a position where we could argue to them, look, this is a good deal, let's move on. And it is a good deal. Again, 4 cents on the dollar, even a 20% settlement's not a bad deal for them.
Yeah, that's fantastic. Okay, great. All right, folks. At this point, we start answering any questions that you have put into the chat. All right, so we're about halfway through the webinar. If you have any questions for me or for John, just go ahead and put them into the chat. I do want to say also, give our standard disclaimer here that we are not your attorneys. I'm not a lawyer. Solicit's not a law firm. John is a lawyer, but he's only licensed in Arizona, and he's not your lawyer. I'm providing legal advice. We're just doing a webinar here already, and we're creating an attorney-client relationship with any of you. Just doing a webinar. All right. So again, if you have any questions, go ahead and put those into the chat, and we'll try to get to them. We got a question here from Sunny. I was sued by Discovery. I have court tomorrow. Called their attorney and I left voicemails, but there was no response. My only income is Social Security. How do I settle if they don't respond?
Yeah, those are tough. And part of what you're dealing with the same thing that lawyers deal with as well, is that the attorneys for particularly junk debt buyers, but collection attorneys, they file a huge volume of lawsuits. Most of them have relatively few attorneys, usually anywhere from 2 to 5 attorneys. Bunch of paralegal type staff, and it can be hard to get anybody to really engage with you with what you're doing. And that's part of the reason why I say sometimes just filing the answer, you're kind of going through this funnel, and now that you filed an answer, you're better than 95% of the people that they sue who don't file answers, and you actually have an attorney assigned to your case who you can deal with a little more directly. It's important to know with Social Security income only, Social Security is exempt in all states under federal and state government, so they can't garnish your Social Security. It might be one that's a good one to go talk to an attorney about and see. You might be judgment proof. I always hesitate to even really kind of talk about that, because even if they get a judgment and you're judgment proof now, it doesn't mean that maybe down the road that you won't be. So you got to be careful with that. But if you're trying to settle it and you can't get hold of them, again, if there's a lawsuit pending and that answer deadline is coming up, get an answer filed. Not only does that protect you from a default, but it puts you in a position it's probably going to be a lot easier to get hold of them, because they actually have to put their contact information and email on the front page of the lawsuit. So that may be a way to kind of spur them along a bit.
Right. Got a question from Tim. Sued by Midland Credit. Court date is next month. Is arbitration still an option for me? What's my best move at this point?
It could be. What you're going to need to look at, it's really determined by the arbitration clause from the creditor, the underlying creditor, the original creditor. And so you need to find out who the original creditor was. You need to get the terms and conditions from that particular card, which if there is a disclosure requirement in your state, they should have provided that to you. If they didn't provide that to you, you can go to the Consumer Financial Protection Bureau's website. They actually have a database of all these credit card agreements, and you can download yours and see if there's an arbitration clause in there. Now, the arbitration clauses in most of these credit card agreements that I see, it does have a timeline, but it says usually that arbitration can be requested at any time as long as judgment hasn't been entered or trial hasn't begun. That's what most of them say, but you'd have to look at yours specifically. So if your trial date's still a month away, I always say the sooner the better. Some judges don't like it if the case has been pending for 9 months and then you file this on the eve of trial. But you could go there and look and get a file quickly because they're going to want to give the other side a chance to respond to it before they rule on it. But I would say get that credit card agreement, double check what it says in there. Sometimes there's one case I had that said that the request for arbitration had to have been requested within 90 days of the answer being filed. It's the only time I've seen that. And I can't even remember which card it was, but go back and check that just to make sure, but you may still have time.
Okay. Yeah, that's good to know. And folks, I just put into the chat a link that you can use to go and create your motion to compel arbitration. That link will support John. So go ahead, and if you're going to do a motion to compel, just go ahead and use that link. I also added in a link for answer documents. If you've got to respond to a lawsuit, you can use that one. All right, jumping on to a question from Navid. I received a pre-legal letter from Midland Credit, also known as MCM, that I settle or they will send it to a lawyer in my state for legal actions. So MCM saying, requesting that that Navid settles, or they'll send it to a lawyer for a lawsuit. This debt is enrolled with Century for settlement. So Century's a big debt settlement firm, and they say it will be settled soon. I'm already in multiple settlements via Century. Other creditors are paying thousands. How do I tell MCM to wait till I settle all of these other debts?
Yeah, and that's always the tricky part with some of these debt settlement companies. What I would do is I would reach out to Century and say, hey, look, I've got this letter. Make sure that you're communicating with them because you hired them to help you to resolve it. What I often see in my practice in Arizona is people will hire a company like that, and then they're trying to help you save up some money, so that they can go out and negotiate. But until they actually reach out and negotiate something, the creditors aren't on board. And so I then see people get hit with all these lawsuits, and it ends up pushing them into a bankruptcy type situation. So I would communicate with Century, first of all, saying, hey, I got this letter. If it's just the normal pre-legal thing they send out, usually nothing's going to happen. It's not like it's going to happen tomorrow or anything. You're likely several months, you might even be a year away from them actually taking legal action. And they may never do it, period. Encore Capital, Midland's parent company, there was actually a really interesting article several years ago in the Wall Street Journal about how they have a whole algorithm as far as who they actually sue, who they don't sue, who they just send letters like that to. So it's something where I would make the company you're working with aware of it, because it could be that this is going to be ramped up a bit, but you likely still have time to try to get it resolved. But I think communication is going to be the key thing there.
Okay. Fantastic. All right. And folks, Hannah is with Solo Suit. She's one of our wonderful assistants on this webinar. She actually puts the webinars together, so you can say thank you to Hannah in the chat if you'd like. She's responding to a lot of your guys' questions here in the chat as well, so be on the lookout for any responses from Hannah. She'll try to respond to anything that we don't get to verbally here in the webinar. All right, jumping on to another question. So, question from Leslie. I have just been paying Midland Credit Management $212 every month until the original debt is paid off. Can I still get the fee lower?
Everything's open to negotiation. As I say, you can always negotiate. Here's what I would, and particularly if you're coming in with a lump sum. My guess is you're not going to be able to negotiate if you're paying $200 a month now and say, no, I want to pay $50. They're probably not going to be open to that. But what you got to be careful with, something I see periodically when people negotiate these things is hopefully you've negotiated that there's no additional interest that's been accruing. I've had people that are doing like that. They're paying $200 a month. They're paying it for 3 years. And they come to me and say, look, they just sent me a statement and I owe more than I did when I started on this thing. And the reason is because the interest, it's not amortizing. It's not covering the interest as it becomes due. So you got to make sure if you're negotiating, particularly a long-term settlement like that, that there's no additional interest that's going on there. But yes, you can reach out. If you have a lump sum and it's, you paid a good chunk already and you're trying to negotiate the balance. I've done that routinely, where we'll reach out and say, look, we paid 3,000. You're saying there's 10 left. We'll give you 6 to make this thing go away, and see if you can get it done that way. So it never hurts. I always say the worst that they're going to say is no, and then you can continue to try to negotiate. There's no downside to that.
Great. This is a crucial idea, right? The idea of stopping interest on a settlement. So are there laws? Do you know of any laws regarding the interest rate ceasing, or is that just something that kind of happens out of the goodwill of the creditor? Because my understanding is that a creditor may cease interest once they've charged off the account. They might cease it once they begin a lawsuit on the account. They might stop interest once they, in terms of a settlement agreement. They also might not do any of those things. They might just let the interest run. Do you know if they're what criteria factor into interest rates?
It's something, definitely you need to be aware of it. What I see with most lawsuits, whether it's Midland or whoever, in the very end of the complaint, what we call the prayer for relief, they always ask for pre-judgment interest at the contract rate, post-judgment interest at the contract rate, or sometimes they'll ask for none. I have seen, particularly in Arizona, old Midland cases where the law firms didn't ask for any interest going forward, which was a pretty huge thing to get. But you need to clarify. And so if they're settling, if you're out there engaging with the settlement and you say, okay, I can do X amount per month, I can make this work, you need to get in writing that they're not going to continue to charge you interest, because it'll cause all kinds of problems. You'll end up, like I said, paying on this for 2 years and end up still owing more than you did when you started. And you're saying, well, why did I do this? But and usually the interest rate they're charging is when they say contract rate of interest, it's usually the default contract rate of interest. Like if you look on your credit card agreement, if you were paying 8% on your credit card, you default on the credit card, it usually jumps up to about 29%. And so this thing, you can see, can spiral out of control really quickly. And so if you're negotiating settlement, make sure that that's clear. There may be certain state, regulations. There's nothing in my state specifically. They're going to, whatever the terms of the contract are, that's what they're going to allow them to charge.
So at the time of litigation in Arizona, most of the time, the debt still has the contract interest rate accruing, in your experience?
Yes, but they're always kind of tricky the way that they do it. Like they'll say, okay, there's $6,500 is the principal amount owed, and that's usually a reference to the charge-off. So 6 months after no payments, there's a charge-off amount, and that's usually the amount that's on the last statement. Mm-hmm. But then I'll see clients that'll say, okay, they sued me for $6,500, then I just got a judgment and it's $13,000. What's going on here? And it's because they asked for pre-judgment contractual interest as well as post-judgment. And so sometimes it's kind of in the fine print of the complaint itself, and they're not actually adding that interest. And I have my own personal opinions on why they do that, because in Arizona, it keeps it in the justice court system, because that's under 10 grand, something like that. But you've got to see exactly what it is that they're asking for, because sometimes you'll get a lawsuit that'll say that, hey, they're suing you for 6 grand, and you reach out and offer them 2, and they're like, well, there's 6 grand, but there's another 4,000 in interest on top. So you've really got to be aware of what the total numbers are and what it is that they're trying to obtain in the long run.
That's fascinating. Yeah. So in our experience at Solo Suit, we see cases pretty regularly. It's not the majority of cases, but we see it pretty common where the interest rate has been stayed before the lawsuit was brought. That sounds like that's not really the case in Arizona.
No, I will say that some creditors do that. Yeah. It's just not all.
Yeah.
And what I see when there's a lawsuit filed, a lot of them will put that language in the complaint to at least leave the door open if they feel they're entitled to it. Whether they seek it or not is, and I've had creditors who will just voluntarily, even they get a judgment, they'll waive, like Arizona has a statutory interest rate of 10% on judgments, even if there's not a contractual rate of interest that's been awarded. And sometimes the creditor will even waive those. It depends on the law firm, the creditor, who it is that's pursuing it and what their policies are on that.
what about post-judgment interest in Arizona? Do you know what the rates are offhand?
Well, I mean, the statutory rate for just judgments in general, what the law says, it's 10%. It said if the parties can, if it's not discernible some other ways, 10%. However, the judges do grant post-judgment interest at the contractual rate. And so that's why, like I said earlier, I always hesitate telling people, hey, if you're judgment proof, maybe you don't need to file an answer. If you're not judgment proof forever, the problem with that, is the judgments in Arizona are good for 10 years, and they can be renewed every 10 years. And so I've seen these, actually had just a brand new client sign up. It's a judgment from 2004, default judgment, $5,000, but there's a contractual rate of interest that's super high. It was like 18 or 20% or something. And now they just filed a writ of garnishment for like $38,000 because they're just churning that interest for years. And so under Arizona law, they can get the contractual rate of interest even after a judgment's been entered. And then if the court awards attorney's fees or court costs, they can get the 10% interest, the statutory rate of interest under Arizona law on that. And so it just turns into this. That's again why I always say file an answer. You don't want this thing to go to default because then you've lost all control over, what's in that judgment. And most judges, they're dealing with these things all day long. If the default comes through, a lot of them are just signing it and moving on to the next one. They may not even know it's in there completely. So you got to be real careful. And that's why filing an answer can help you avoid a lot of that.
So the statutory interest rate that's applied in Arizona if you lose your case is 10%.
Correct.
Yeah. It can't be higher than that, right? It's just 10% is like the amount.
10% is usually for the attorney's fees and court costs, and then they will allow them to seek the contractual rate of interest if they ask for it. If not, and if the judgment is silent as to an interest rate, the default is that 10% is accruing on it as it goes forward. On
the total balance of the judgment.
Total balance, correct.
Yeah. So in theory, if you had a 29% contractual rate, it would be 29% plus the 10%, and you'd get a 39% interest rate. Is that how that would?
You could. Correct. Yeah.
Yeah. Compounding monthly, I suppose. Something along those lines.
It's an annual rate, yeah, but it's you can see that, like I said, we see these routinely as really old judgments where it's just out of control, and it gets difficult to even settle, and it forces a lot of people into the bankruptcy if you have this 15-year-old judgment that's been churning interest for more than a decade at this super high rate. It gets really crazy.
Right. Yeah, it could get out of control real fast.
Yeah.
All right, folks. So that's half past. That brings us half past the hour. Hope you enjoyed the webinar. Hopefully we got to your questions. I know there's a lot of questions here that we didn't get to. If we didn't get to them, hopefully Hannah did. If you still have a question that's unanswered, you can email us at support@solosuit.com, and we will get you taken care of. And then once again, here is the link that will support John if you want to respond to the debt lawsuit. Just going to go ahead and put that into the chat here. All right, and then John, where can people follow you or find out more about your services?
Like I said, my website is consumerwarrior.com, or just on YouTube. Same thing, Consumer Warrior YouTube channel. Just put that in. You'll be able to find me.
Alrighty. Fantastic. Well, thanks for coming on to the show today. Very good to see everybody.